Hi everyone, I am Veena. Today my topic is legal system in India. With a very recent statement made by President Ramnath Kovind, where he mentioned about the long pending case in the various courts in India. In this presentation, I have tried and made an attempt to analyze the various alternate dispute resolution mechanisms that are available with the company secretary professional. You would have heard the very recent statement made by President Ramnath Kovind. His statement was, Indian legal system is marked by long delays, huge backlog of cases in court. Now this statement of the President actually made me think of the alternate dispute resolution mechanism. Why is that we actually have to put our matters in the court when we know that there are already so many matters which are pending there? To our surprises, now as far as the statistics is concerned, we understand that there are 3.3 crores matters which are pending at various courts. Now in terms of flow of presentation, we will today talk about the legal systems in India, then we'll talk about the alternate dispute resolution mechanism, and then we will talk about the alternate dispute resolution mechanism under the Companies Act. As far as the legal system is concerned, we need to understand that the matter in India first goes to the subordinate court, followed by the High Court, and then to the Supreme Court of India. Now when we talk about alternate dispute resolution, the first statement that comes to our mind is a statement which is given by Abraham Lincoln. What is he saying? He mentions, discourage litigation, persuade your neighbors to compromise whatever you can, point out to them how the normal winner is often a loser in terms of the fees, expense, cost and time. Isn't it true? It is definitely true, and so it's very important for us to actually refer matter towards alternate dispute resolution. Now before we get there, let's first understand what is alternate dispute resolution. Now from a layman perspective, we need to understand that alternate dispute resolution, as the name suggests, is a dispute resolution mechanism. This is a substitute to the conventional methods of resolving dispute. Now as far as the alternate dispute resolution is concerned, it's about the use of a third party. Now this third party is a neutral third party who helps parties in terms of resolving the dispute. What are the mechanisms which are available to us? As far as the mechanism for alternate dispute resolution are available, we need to understand that we've got number 1, mediation, number 2, conciliation, and then number 3, we have got arbitration. Now the question that must be coming to your mind is, what is mediation and what is conciliation? Now mediation and conciliation, they both are alternate dispute resolution mechanism where a third party, who is the neutral third party, which is called as a mediator and conciliator. Now this third party would try resolving dispute between the parties and would enable the parties at arriving at conclusion, would enable the parties to arrive at settlement. Now what happens in this case, and what is the beauty of this matter, is that this is a process where parties to the dispute would actually decide what they would want in terms of resolution, what they would want in terms of solving the matter. Now that is the beauty of mediation and conciliation. As far as arbitration is concerned, we need to understand that this is again where we've got a third party called arbitrator who is there, and this is something which is governed by Arbitration and Conciliation Act. Now let's look at the mediation and conciliation under the Companies Act. Now the Companies Act is a huge corporate law, and from our perspective, we as professionals would want to try and put matters under mediation and conciliation, because we definitely do not want to put pressure onto the courts which are where there is a huge burden. The first question that must be coming to your mind is, who can refer the matter to mediation and conciliation? So we need to understand that as far as matters to mediation and conciliation are concerned, any party who's subject to the dispute, any party whose matter is pending before any of the court, they can refer the matter to the mediation and conciliation. And how would they do that? They would do that by way of a form which is called as MDC2. That's a form which is available under the rules. So any party who is a party to the dispute can fill this form and can submit this to the central government, to the tribunal or to the appellate tribunal, requesting them to refer their matter to the mediation and conciliation. The point 2, the part 2 for this is that if central government or the tribunal or the appellate tribunal feels that the matter should be referred to the mediation and conciliation, they can suo motu do that. Now let's understand the procedure. So I hope by now you've understood that who can appoint a mediator. Very much it depends on the parties themselves, or if the central government or the appellate tribunal or the tribunal they feel so, they may do that on suo motu basis. As far as appointment of mediation and conciliation is concerned, we need to understand that there is a panel of expert which is maintained at the MCA website. The link is provided here. Now in that, what happens is that the parties may agree to appoint a sole mediator. So that's one option, where the parties have an option to appoint sole mediator. If each party feels that they don't want to appoint a sole mediator and they want to have their own nominated mediator, well, they can do that as well. Or if the central government, if they seek to, if the parties want to take a help of the central government or the tribunal concerned, they may also help parties in identifying the mediator or conciliator. Now let's look at the mediation and conciliation proceeding. Now first point here is fixing the date. As far as the date is concerned, we need to understand that a mediator or conciliator would fix the date and time for the matter and where the parties are expected to be present. Now point number 2, as far as the place of hearing is concerned, we need to understand that the parties may jointly agree as far as the place of mediation or conciliation is concerned. Now as far as meeting is concerned, depending on how comfortable the parties are, they may want to have either a joint meeting or a separate meetings. Point number 4, and which is very important in this case, is that each party shall submit at least 10 days prior. Before a session, the parties are expected to submit a document called memorandum. Now that something is required to be submitted, and there is a timeline of 10 days that the parties have to adhere to. Then the beauty of this case is that the parties themselves present will decide on the matter. They will decide what needs to be done or what they are agreeable for. They can do that. Or if the parties feel that they wish to send an authorized signatory, they can do that. Now, very important point here that you need to understand is that if the parties fail to attend to mediation or conciliation meetings, as far as that is concerned, we need to understand that if the parties would fail to attend to mediation or conciliation, that mediation or conciliation will be considered as failed. Now, as far as point number 6 is concerned, there is something called as settlement agreement. If the mediation or conciliation is successful and if the parties have arrived at settlement, there is something called as a settlement agreement which is signed between the two parties. Now, this settlement agreement is then submitted to the tribunal or the central government concerned. Now what happens then is that once the central government or the tribunal or the appellate tribunal would receive this copy of settlement agreement, they would then fix up an order hearing date within 14 days, and then they would pass an order basis the settlement agreement which has been agreed between the parties. Matters which cannot be referred to mediation or conciliation. Let's understand. Now these are matters which cannot be going to mediation or conciliation. What are these matters? Point number 1, matters pertaining to inspection and investigation. Now this is something of a serious nature, hence this is not something which can go to mediation or conciliation. Point number 2, matters pertaining to which there is already a compounding application started. So when the compounding application is already started, parties cannot refer that matter to mediation or conciliation. Point number 3, cases involving serious allegations like fraud, fabrication of documents, forgery. Now these are matters which cannot be going towards the mediation or conciliation. Point number 4 here are matters involving prosecution for criminal and non-compoundable offences, and then towards the end we've got cases which involve public interest. Now these are matters which cannot be going to the mediation or conciliation. I hope you find this presentation helpful from the perspective of understanding the alternate dispute resolution available under the Companies Act. Also, if there are any comments that you wish to share, or if there's any discussion that you want to have, please feel free to put your comments in the comment section below. Thank you so much.